Well, if you declare an entire group of individuals who are born here and who have grown up here in many instances to not be United States citizens, you're essentially creating hereditary caste systems in which certain individuals will be essentially have no place that they can call home. They were born here as children, they've grown up here as children, and even if the ruling is only prospective, which it really would have to be, you're going to have a whole range of logistical and frankly equal rights questions. When someone is born in a hospital, do you really want the hospital to be focused first and initially on testing the citizenship of the parents in that instance? This is potentially Pandora's box in terms of civil rights in the most severe.
You just heard that voice trembling with urgency and precision, spelling out something that should terrify every single person who claims to understand what makes America different from the authoritarian nightmares that scar human history. Because what we're witnessing right now is the Supreme Court agreed Friday to decide if President Donald Trump's attempt to end birthright citizenship with an executive order is constitutional, not some dry academic dispute about immigration policy or bureaucratic procedure, but an existential assault on the very architecture of equal citizenship itself. The Supreme Court is directly taking on the merits of what has widely been considered settled law since the 19th century, and I cannot overstate how breathtaking that is, because we are talking about overturning more than a century of legal understanding that protects every single person born on this soil from becoming a permanent subclass of stateless people, whose legal status becomes a question mark passed down through generations like some feudal birthright in reverse. Listen to me when I tell you this, because the stakes here are cosmically higher than the sanitized legal language suggests. And here's your first bombshell that should send shivers down your spine. No lower court that has been confronted with legal challenges to the birthright citizenship order has embraced the Trump administration's interpretation of the 14th Amendment's citizenship clause. Not one. Every single federal judge who has examined this scheme has recoiled from its constitutional deformity, and yet here we are with a Supreme Court that has been systematically captured by right-wing ideologues agreeing to take up what should be laughable on its face, because Trump has sought to unravel that historical understanding, embracing a hitherto fringe theory pushed by anti-immigration activists. This is how authoritarianism metastasizes in real time, through the legitimization of what was yesterday considered beyond the pale of serious legal thought, transforming into tomorrow's constitutional precedent. And let me tell you what the architecture of this nightmare actually looks like in the practice, because when the legal expert in that clip uses the phrase hereditary caste system, they are not being hyperbolic or reaching for inflammatory rhetoric, but describing with clinical precision what happens when citizenship becomes contingent on your parents' legal status at the moment of your birth. It avoids the creation of a hereditary caste of people who are not citizens, and whose children will not be citizens, and whose children's children will not be citizens, and are therefore vulnerable to exploitation, as Harvard law professor Gerald Newman explains with devastating clarity. Think about that for 1 second, because we're talking about creating entire bloodlines of people born in America who would have no legal home anywhere on Earth, living in perpetual legal limbo generation after generation, while working the jobs and paying into the systems and contributing to the communities that would never recognize them as full human beings under the law. Now here comes bombshell number 2, that should make your blood absolutely boil. Trump's executive order said that the federal government will not issue documents recognizing United States citizenship to any children born on American soil, to parents who were in the country unlawfully, or were in the states lawfully, but temporarily. Do you understand what that means in practical human terms? Because it means that if you're born in a hospital in Los Angeles or New York, or anywhere in this country, and your mother happened to be here on a student visa, or a work visa, or crossed the border seeking asylum, your birth certificate would be marked with a scarlet letter of non-belonging that would follow you for your entire existence. The cruelty is not incidental here, but definitional, because birthright citizenship would be limited to those who have at least one parent who is a U.S. citizen or permanent legal resident, and would not apply to babies born to temporary visitors who entered the country legally, or to people who entered the country illegally. And let's talk about the Orwellian nightmare scenario that the expert describes with such appropriate horror about hospitals being transformed from places of healing into immigration enforcement checkpoints, because imagine you're about to give birth and instead of medical professionals focusing entirely on keeping you and your baby alive and healthy, they're first obligated to interrogate your citizenship status and your partner's citizenship status before they can even determine what kind of birth certificate to issue. Birthright citizenship is not a privilege granted at the government's discretion, but a constitutional guarantee that protects all individuals born on U.S. soil, preventing the creation of a hereditary caste system based on lineage rather than law. And the moment we allow that guarantee to be shredded, we open Pandora's box to surveillance and discrimination and bureaucratic violence that would permeate every single institution in American life. But wait, because here's bombshell number 3, and this one should absolutely enrage you. This entire legal crusade is happening at the exact same moment when the U.S. Supreme Court issued a decision that clears the way for racial profiling during immigration raids and sweeps, and the Trump administration could rapidly expand the racially discriminatory ICE practices that terrorize families, workplaces, and communities, and these raids are more likely to sweep in U.S. citizens and people with lawful status. Do you see how these two developments work together like interlocking gears in a machine designed to create a two-tiered system of citizenship, where your rights depend on what you look like and how you sound, and where your parents came from? The Supreme Court rejected lower courts' rulings which said parts of Trump's immigration operations involving armed and masked immigration and customs enforcement agents pulling aside people who look Latino violated Fourth Amendment rights, and those rulings prohibited the government from detaining people based on race, whether they spoke Spanish or English with an accent, their presence at places frequented by immigrants, or their employment at jobs usually held by immigrants, and now all those protections are gone. Let me ground this in the historical precedent that makes crystal clear what the 14th Amendment was designed to prevent, because birthright citizenship was added to the Constitution in 1868, when the 14th Amendment was adopted following the Civil War, and the Citizenship Clause provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens, and the amendment was intended to overrule the Supreme Court's most notorious decisions, its 1857 ruling in Dred Scott v. Sanford. This is not ancient history disconnected from our present crisis, but the through line of American struggle between the forces that believe in universal human dignity, enshrined in law, and the forces that insist some people are inherently more deserving of rights than others, based on the circumstances of their birth. The architects of Reconstruction understood with brutal clarity that you cannot have a functioning democracy when entire categories of people born within your borders are denied the basic recognition of citizenship, because that creates exactly the kind of permanent underclass that makes fascism possible. And here's where the conservative legal strategy reveals its absolutely sinister genius. The Trump administration told the Supreme Court that the notion that birthright citizenship extends broadly has destructive consequences, and the Solicitor General told the court that the Citizenship Clause of the 14th Amendment was adopted to grant citizenship to newly freed slaves and their children, not to the children of temporary visitors or illegal aliens. This is the originalist argument stripped down to its bare white nationalist bones, because it takes a constitutional amendment written specifically to prevent the creation of a hereditary underclass and weaponizes it to create precisely that by arguing the framers only meant to protect one specific oppressed group at one specific moment in history, rather than establishing a universal principle of just solely citizenship that had been the common law tradition for centuries before. Now let me tell you about bombshell number 4, that demonstrates just how radical and unprecedented this assault actually is. The Supreme Court addressed the issue 127 years ago, ruling in 1898 that the Citizenship Clause ties U.S. citizenship to place of birth in the landmark case of United States v. Wong Kim Ark. The Supreme Court ruled in favor of Wong Kim Ark, who was born in California to parents of Chinese descent, and by a vote of 6-2, the court rejected the government's argument that Wong Kim Ark was not a U.S. citizen. This was not some narrow technical ruling, but a sweeping affirmation that the 14th Amendment meant exactly what it said, with only the narrowest exceptions for children of foreign diplomats and invading armies. Legal scholars of all ideological stripes have generally assumed the phrase to be self-explanatory, with the only exceptions being people born to foreign diplomats, invading hostile forces, and members of some Native American tribes, and yet here we are with a conservative Supreme Court, seriously entertaining arguments that every legal scholar until about 5 minutes ago would have dismissed as constitutional illiteracy. And I want you to understand the procedural jujitsu that Trump and his Solicitor General are deploying here, because the Trump Justice Department's litigation strategy suggests some doubt within the administration about how the justices will rule, and the government launched a half-measure, procedural appeal to curb the use of nationwide injunctions, rather than urge the justices to immediately deem the underlying policy lawful. They know how legally tenuous their position is, so they first went after the ability of lower courts to issue nationwide injunctions, knowing that if they could fragment the opposition and create chaos in the system, they might eventually wear down resistance to their core constitutional violation. In June, the court split 6-3 to side with the administration in that procedural case, which didn't address the underlying legality of Trump's proposed citizenship restrictions, and now they're back for round 2, emboldened by that procedural victory to take on the merits. But here's what should terrify you about the timeline, because the case will be argued in the spring, and a definitive ruling is expected by early summer, which means that by July of next year we could be living in a fundamentally different constitutional order, where millions of people born in the United States wake up to discover that their government no longer recognizes them as citizens. The order would apply only to people born 30 days after the order was signed, on January 2025, so we're talking about a prospective stripping of citizenship that would apply to babies being born right now this very moment, whose parents are on temporary visas, or who cross the border seeking refuge from violence and persecution in their home countries. These are not abstractions or hypotheticals, but actual human beings, whose entire life trajectories hang in the balance of what 5 justices decide behind closed doors. Let me paint you the picture of what this hereditary caste system looks like in practice once it's fully operational, because we don't have to speculate when we can look at historical and contemporary examples. A system based on genetic parentage risks creating a large class of stateless individuals, particularly children born in the U.S., to undocumented or temporary status parents, who may not have citizenship in any other country, and this could lead to widespread exclusion and instability. Think about a child born in Houston, whose mother was here on an expired tourist visa, and whose father returned to Honduras before the birth, meaning that child would have no claim to American citizenship in the country where they were born and raised, but also no claim to Honduran citizenship, because Honduras doesn't grant citizenship based on parental descent, if the child wasn't born there. Congratulations, you've just created a stateless person, a legal ghost who exists in no country's records as a full human being, with rights and protections, and there are international conventions against created stateless people, precisely because history has shown us again and again what happens when human beings lack the protection of any nation. And here's bombshell number 5, that connects this to the broader authoritarian project. The administration is facing multiple court challenges, and the Supreme Court effectively stopped the use of the Alien Enemies Act to rapidly deport alleged Venezuelan gang members without court hearings, but the Supreme Court allowed the resumption of sweeping immigration stops in the Los Angeles area. Do you see the pattern emerging where the court draws totally arbitrary lines about which flagrant violations of constitutional rights they'll tolerate and which ones they'll temporarily pause, creating maximum chaos and fear in immigrant communities, while preserving just enough plausible deniability to pretend they're not full participants in Trump's thorough, ethnic cleansing agenda? President Donald Trump has hobbled independent agencies, and in May, the court allowed Trump to temporarily remove officials at the Merit Systems Protection Board and the National Labor Relations Board, so the infrastructure for checking executive power is being systematically dismantled at the same moment when that executive power is being deployed to fundamentally redefine who counts as an American. Now I need you to understand the historical resonance here, because the language of hereditary caste is not accidentally chosen, but deliberately invoked to connect our present moment to the long global history of systems designed to keep certain populations permanently subordinate. Birthright citizenship prevents the creation of a hereditary caste system based on lineage rather than law, and when we look at actual caste systems from the Indian subcontinent to feudal Japan to the Jim Crow South, what we see is the systematic use of birth status to determine every aspect of a person's life, from what jobs they can hold, to who they can marry, to whether they can access public spaces and resources. The whole point of birthright citizenship, as understood by the framers of the 14th Amendment, was to sever the link between parental status and civic belonging, so that America would be defined by territorial birth rather than bloodline. But Trump wants to restore that blood-based system cloaked in the language of immigration enforcement. And let's talk about who gets swept up in this dragnet, because the right would not apply to babies born to temporary visitors who entered the country legally, or to people who entered the country illegally, and the administration's legal argument is that the subject to the jurisdiction thereof language confers citizenship upon only children who are not just present in the United States, but also bear allegiance to it. Think about how insane that standard is when applied to newborn infants, who by definition cannot bear allegiance to anything except maybe their next meal. We're talking about attributing political loyalty to babies based on a metaphysical theory of inherited obligation that would have made medieval theologians blush. But the real purpose becomes clear when you realize this creates the discretionary power to determine citizenship based on immigration status, which inevitably means based on race and national origin and perceived foreignness. Here's bombshell number 6, and this one should make you absolutely furious about the hypocrisy at the heart of conservative jurisprudence. The administration's interpretation is not merely mistaken, but either a crazy theory or a dishonest interpretation of the Constitution, and the executive order ignores every relevant interpretive source, text, precedent, and long-standing practice, and replaces them with a theory the Supreme Court foreclosed over a century ago. Where are all the originalists now screaming about adhering to the plain text of the Constitution, because all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens, is about as clear as constitutional language gets. The 14th Amendment was ratified to repudiate Dred Scott, and to prevent the creation of a hereditary class of non-citizens within the United States, which is literally the exact outcome that Trump's executive order would create. But conservative originalism has always been a cynical shell game used to launder reactionary policy preferences through the superficial legitimacy of constitutional interpretation. And we need to talk about the international context, because birthright citizenship based on the location of birth is common within our neighbors in North America and throughout the Western Hemisphere, but highly unusual in other parts of the world, and what should dictate the way in which citizenship law evolves moving forward is the text of the 14th Amendment. The Trump administration wants to gesture toward restrictive citizenship regimes in places like Germany or Japan, as if we should model American citizenship on ethno-nationalist states that define belonging through blood quantum and hereditary descent. But America's entire civic identity has been built on the principle of territorial citizenship, precisely because we are a nation of immigrants that theoretically rejected the old world hierarchies of aristocracy and inherited status. To adopt the citizenship models of countries with explicit or implicit ethnic definitions of national belonging would be to abandon the one distinctive feature of American democracy that set it apart from European nationalism. Let me tell you about bombshell number 7, because the procedural violence happening here is just as important as the substantive violation. Executive Order 1416-0 not only contradicts well-settled 14th Amendment doctrine, it also appears to violate basic separation of powers principles, because citizenship rules are fixed in the Constitution and may be altered only through the amendment process, and no president may redefine constitutional citizenship by unilateral directive, yet that is precisely what Executive Order 1416A attempts to do. Think about the staggering arrogance and authoritarian presumption at work when a president decides he can simply ignore 150 years of constitutional interpretation and statutory law with the stroke of a pen. The President of the United States has no authority to change citizenship rules at all, and both history and Supreme Court precedent confirm an intent to grant citizenship to anyone born in the U.S., regardless of their parents' legal status. As Professor Newman emphasizes, this is textbook executive book overreach of the kind that should have every person who claims to care about limited government and constitutional constraints absolutely losing their minds. But where are the so-called constitutional conservatives now that their guy is the one shredding the founding document? And here's what makes this particularly insidious. The Trump administration knows that even if they ultimately lose this case at the Supreme Court, they will have achieved years of terrorizing immigrant communities and creating chaos in the citizenship documentation system and emboldening state and local officials to discriminate against anyone who looks or sounds foreign. Some said they had been taking precautions for months, or since Trump took office, that now feel justified, and Francisco Moreno, a naturalized citizen, said he has been carrying around his proof of U.S. citizenship since widespread immigration raids began. American citizens who happen to be Latino or speak with accents are already living in a state of heightened surveillance and fear, carrying their papers at all times, like it's 1930s Germany, and this is happening right now before any final ruling on birthright citizenship, which tells you everything you need to know about how the mere threat of citizenship revocation functions as a tool of social control and ethnic intimidation. Now let's talk about the logistical nightmare that would ensue if this policy were actually implemented, because requiring proof of parental citizenship would add a heavy bureaucratic burden, forcing individuals to undergo complex documentation processes that could disproportionately affect marginalized communities. How exactly do hospitals determine in the delivery room whether both parents are citizens or permanent residents? Do they delay emergency medical care to check papers? What happens when one parent is absent or their status is unclear, or they're fleeing domestic violence and don't have contact with the father? Who bears the burden of proving citizenship, and what counts as sufficient proof when we know that poor communities and communities of color are systematically less likely to have comprehensive documentation? Birthright citizenship makes it really easy for citizens to prove they are citizens, because if you've got a birth certificate showing you were born in the United States, that's how you prove your citizenship. But once you destroy that simple territorial rule, you create infinite opportunities for bureaucratic harassment and arbitrary denial of rights. Here's bombshell number 8, and this connects to the broader conservative legal project of the last several decades. Justice Sonia Sotomayor wrote that for the government to win on the merits of the citizenship issue, it would have to show that the order is likely constitutional, an impossible task in light of the Constitution's text, history, this court's precedents, federal law, and executive branch practice. Even the conservative justices have to know how shaky this ground is, which is why they engaged in that procedural sleight of hand earlier this year. But now they've agreed to take up the merits, which means either they're genuinely willing to overturn 127 years of precedent and create constant chaos, or they're planning some kind of narrow ruling that technically preserves birthright citizenship while gutting it of meaningful protection. Neither option is acceptable, and both represent catastrophic failures of judicial responsibility, and we have to confront the white nationalist ideologies at the heart of this entire project, because when Trump and his enablers talk about birthright citizenship, they're not really concerned about abstract questions of constitutional interpretation, but about the demographic reality that America is becoming majority-minority, and that terrifies them. Validating the president's executive order barring U.S.-born children of undocumented immigrants from U.S. citizenship would overrule a right guaranteed by the 14th Amendment and upheld by SCOTUS over a century ago, and the belief that U.S.-born children of undocumented immigrants have no rights to citizenship was once a fringe idea, but Trump has brought the issue into the mainstream. This is how fascism works, through the systematic normalization of what was previously unthinkable, so that by the time the final authoritarian move happens, half the country thinks it's reasonable, because we've been conditioned by years of incrementally expanding cruelty and dehumanization. Let me tell you about bombshell number 9, because the historical parallels here are absolutely chilling. The Supreme Court's 1898 decision in United States v. Wong Kim Ark ruled that the 14th Amendment guaranteed U.S. citizenship to any person born on U.S. soil, and it was a watershed moment for immigrants, and the case concerned Wong Kim Ark, a man born in California to Chinese immigrants, who returned to the U.S. after visiting family in China, and was refused re-entry, and John Wise, the collector of customs in San Francisco, wanted a test case that would deny U.S. citizenship to ethnic Chinese residents. Parameter, invoking